Welcome to Partnered Up Business Law, Deals, and Dynamics.
Welcome to Partnered Up Business Law, Deals, and Dynamics with Jeff Fink, partner at Coren Lichtenstein LLP in Massachusetts. Jeff advises business owners and partners on formation, growth, and dispute resolution for closely held companies. I'm Evan Mack, and today we're talking about corporations, shareholder agreements, and how business owners structure control, ownership, and decision-making from the start. Jeff, welcome back, brother.
Thanks, Evan. Good to see you.
Good to see you too, Jeff. So you talk about the partnerships and LLCs a lot on the podcast, but how are corporations different?
Let's even start before corporations. What we now call general partnerships have existed for a long time. So all you need is two people to say, we're partners, you got a partnership. The problem is they both have full liability for the business. So each one puts in $10. Each one takes out an equal share. All is great. But then if the business has a $100 debt, they're both individually liable for the full, jointly and severally, for the full amount of that $80. So that's great if you got a couple of people working together. When you need to put more money together to do bigger things, it doesn't really work. So corporations are different. They really revolutionized the business world when the first statutes were being passed in the early 1800s, because they limited the liability of the owners to the amount they had invested in business, with some exceptions we can talk about another time. So that means if both owners put in $10 and the business had a $100 debt, they're still only at risk of losing that $10. Somebody can't come after the rest of their assets. And so what that meant is that you could get bigger and bigger pools of money. It was originally big manufacturing businesses that used it. In fact, some of the early statutes were limited to manufacturing businesses, but it really took off with railroads, actually. So we talk about LLCs a lot. They, like corporations, they offer limited liability for the owners. The corporations are a lot older. The first LLC statutes didn't come into effect until the 70s, and they didn't really take off until the early 1990s. So people just don't know them as well. So the difference from a business perspective is how they're taxed. So from a really high level, simplified view, most LLCs are taxed as partnerships, which means they file a partnership tax return and pass through their income, the items of net income and net loss, to their members on it's called the Schedule K1, is the tax return you get at the end of the year. They don't pay taxes on their own income. Most corporations, and they're talking about something called a C corporation. I'll talk a little more about that in a minute. They file a corporate tax return, they pay taxes on that income, and then if there's money that's going to come out to the shareholders, it has to come out usually as a dividend, and then the shareholders pay another layer of tax on that. So there's some special deductions that can change the picture, but that's the overview. So right now, even though most new businesses in the U.S. are formed as LLCs, law students still spend a lot more time learning about corporations just because they've been around longer. Their professors understand it better. For bigger entities, they are very important still. Business people, lawyers, and ultimately judges just understand that corporate framework better. And by the way, today I may use the words shareholder and stockholder interchangeably. And the reason we use both words is that the statutes have different terms. Like the Delaware Corporation statute talks about stock and stockholders, and New York and Massachusetts, for example, talk about shares and shareholders. So we use the right words in legal documents, but in normal human talk, we don't have to.
So when would you recommend that people form a corporation, and when would you recommend they, use a different kind of entity?
Good question. It's usually not that complicated, but accountants and lawyers love making mountains out of molehills. It's called the choice of entity problem. And so a lot of both lawyers and accountants will list choice of entity as a thing on their website that they do. Pretty much if it's going to be and stay a small business, LLCs are much more common these days. There are more tax advantages, and the entities are more flexible. For certain kinds of businesses like real estate development entities or investment entities like private equity or other funds, LLCs or some relatives of them may almost always make more sense. Um, you should think about a traditional C corporation if the entity is going to have a lot of owners who aren't going to be part of the operating business. That was the original purpose of it. Everybody buys a little piece of the factory, even though the factory these days could be somebody who's developing some technology. So one of the things that means is that a growing business that's going to be looking for investors, particularly venture investors, is probably best off as a C corporation. Except in the case of these pooled investment funds, the presence of institutional investors also pushes you toward a corporate entity because of the way they have to treat their own investors. Investors in like a private equity fund or a venture capital fund don't want to get K-1s from operating businesses. And some of the reasons is because that creates real problems for pension fund investors who are the money that back a lot of these. So I mentioned S corporations before, and it's named an S corp because they used to call them subchapter S corporations because it's from subchapter S of the Internal Revenue Code. When do you use one? So an LLC owner can't really be an employee. You can get guaranteed payments out, but you can't get a W-2. S corporation employees or owners can be employees, which means part of their employment taxes, the FICA part, the Social Security taxes, get capped if they're paid a salary. And so if you're expecting to make a lot of money, you might want to go toward that S corporation structure because then that's going to cut down on the maximum taxes that you're paying. So whether it's worth the effort to do that depends on how much the owners expect to get paid. A couple of other things that push you in one direction or another. Pass-through entities like LLCs don't necessarily make sense for foreign investors or some regulated businesses in which owners don't want pass-through income. Like in the cannabis industry, we see a lot of LLCs that elect to be taxed as corporations. So you have the flexibility of the LLC structure, but you can elect to be that corporate tax. But that's really a special case. Don't see that much outside that industry. There are also special use cases for other kinds of entities like limited partnerships, limited liability partnerships, and trusts, but that goes way beyond what we can cover today. So kind of sum it up, most of the time, think LLCs for smaller entities with fewer shareholders or a lot of tax advantages to pass through. S corporations for businesses where it makes sense for the owners to be employees, and C corporations for bigger entities or growing entities with more shareholders that kind of need that institutional feel to them.
How do you create a corporation? How is a corporation law different from that LLC law?
So corporations and LLCs are separate legal entities created by a filing with the state. The LLC formation documents are pretty vanilla. They just say, I'm forming an LLC. Corporation documents have to have more stuff in them, and then they can have a lot more stuff in them. They get more complicated because some of what you put in an LLC operating agreement goes into the state filing. One thing to keep in mind is there is no federal law in the United States that makes a corporation. It's all state by state, and the states are different. So what's the best way to think of it? So corporation laws provide a lot of structure for the business. So if you think of it like a not very appetizing layer cake. So bottom layer is the corporation law that supports how everything works. There's a statute and this huge body of case law that interprets the statute and fills in things like fiduciary duties that fill in any blanks in the structure. So next layer is the certificate of incorporation that creates the company. Next layer is the bylaws that say how it runs. Board resolutions, which you really need more of in a corporation for various reasons than you do in an LLC. They're like the icing on the top of the cake that address some of the big picture strategic and operational issues. And then there's a shareholders agreement. It's kind of like the decoration on the cake. You don't really need it, but the cake looks unfinished without it. It's for a privately held company, especially as you get more and more shareholders, it becomes really, really important. It spells out a bunch of rights and obligations the shareholders they wouldn't otherwise have. And they can get complicated. So the way you can have different classes of members in an LLC that have different rights is harder to do with a corporation. Pieces of go into the certificate of incorporation, like the terms of preferred stock, which is a separate podcast episode, but a lot happens in a shareholders agreement. You build up that structure you want through different documents, so you really have to understand the whole picture of where you're getting. And that structure can really help as a practical matter. So I once represented an LLC that had 3 members, all of whom thought they could do everything, and they were really pulling the business in 3 different directions. That situation is not something you'll see with a corporation. So in a corporation, the shareholders elect the board elects the officers. You have to have at least 3 offices filled by statute, president, treasurer, and secretary. So directly or indirectly, the president is in charge of the day-to-day business and answers to the board as representatives of the shareholders. So if there are 3 shareholders who are all in the business, somebody's going to be president. And a majority vote on the board is going to decide big picture of things, including who the president is. Yeah, so it's just, that structure is sometimes helpful. You can write that into a limited liability company, but it's just there by default with a corporation.
When would you form a corporation in Delaware, or maybe when would you choose another state?
Good question. So every state has a corporation statute and a big body of case law, and they're different. The concepts are the same, but they address them in different ways. So in our practice, we usually use Massachusetts law for businesses that will stay local, and Delaware law for bigger or growth-oriented businesses. So Massachusetts is much, and a lot of states, frankly, are much easier and less expensive to deal with than Delaware is. So the admin burden's less. Massachusetts is kind of the opposite of Delaware in a way. Shareholders of small Massachusetts corporations owe each other much more in the way of fiduciary duties than in Delaware. And that can be good or bad, depending on how much insulation you want as the founder. Delaware does tend to be more sophisticated, and if you end up in court for some reason, the Delaware Chancery Court's one of the best in the countries. And also investors know Delaware more than they know most states, so it will give them some comfort that they're buying into a known quantity if you're looking for investors. As a final thing to think about, this is sometimes meaningful to people. In a lot of states, you can pull corporation documents offline and see who the directors and officers are. In Delaware, there's less in the public record than in most states, and what's there isn't really searchable. So you get a higher level of anonymity, really. So, it's not that you're necessarily hiding the fact that you're a director of a company or an officer of a company. It's just harder for people to find that online, and that's an important thing for some people.
What are some of the general matters that people typically include in these shareholder agreements?
So we did a couple of episodes on LLC agreements, and like we talked about a minute ago, shareholders agreements do some of the same things. So for the rest of this episode and the next episode, we'll go into more detail about it. So a typical shareholders agreement for a privately held company covers a handful of items. One is restrictions on transferring shares. And you have to put something on the back of a stock certificate that says transfer of these shares is restricted. It's just, just a legal thing, but that'll be spelled out in the shareholders agreement. It's called a legend. So sometimes you give specific shareholders or groups of shareholders rights to elect and remove directors. You'll get protective provisions for minority owners that give them the right to approve certain actions by the corporation, like sale of the company or related party transactions. not for all minority shareholders, but particularly big groups of investors get that. You'll have things that give the company or other shareholders a right of first refusal or right of first offer. Sometimes we see something called preemptive rights, which is the right to participate in future sales of securities, future investment rounds by the company. Two very important pieces are called drag-along rights and tag-along rights. We'll talk about those in more detail. And you really have to think about when the shareholders agreement ends, because, you start off with, Bob and John forming a company together and maybe getting some investors in. By the time it's a public company, most of the stuff doesn't mean anything, because they're really aimed at certain size entities with certain levels of complexity in their cap table. So that is a reason to review them regularly. It's not like there's just a one size fits all form you can print off the internet. So usually we put something in for private companies about the agreement ending if it goes public. You might have earlier time periods too. As with everything, there's an exception, because there's sometimes where you have a shareholders agreement for a big investor or groups of investors in a public company, but that's really a special case. When I was first learning about these things, for companies that were expected to grow until they became a public company, we put something called registration rights into a separate agreement. Now you do see them. The public market isn't necessarily the goal that people have. A lot of times people just want to grow until somebody buys them. That's how they get their liquidity. But for the right company, you need them anyway. They give big shareholders the right to demand registration of their shares with the SEC, so-called demand rights, or participate in the registration the company's already doing. Those participation rights, people call those piggyback registration rights. Nowadays, some lawyers include them in the main shareholders agreement if there are a limited number of shareholders, just as a drafting matter. I don't like doing that, because different groups of people can have different groups of shareholders can end up with different rights, which is complicated to draft into a single document.
So to kind of wrap things up, how do shareholder agreements address board composition, including who sits on the board and any requirements to vote for certain directors?
It's the control question. Everybody wants to be in control. So the bylaws say how big the board is. Usually a minimum, maximum, like between 3 and 5 directors. Odd numbers are better, so there's not a tie vote. The problem is that if you're an investor who holds a big minority interest, like you're a 40% shareholder, you wouldn't necessarily have the right to have the seat on the board, because the election is by majority. So to protect yourself, you negotiate a right to have that seat into the shareholders agreement. The way it works mechanically is that you require all the people who are signing the agreement, so ideally all the shareholders, to vote for a board candidate you suggest. Going along with that, if you don't like how that director is doing, or if you're the director and you want to step back and have someone else do the work, you can require that all the signatories vote for removal or replacement. So the same idea can apply if you have a group of investors who are going into business at the same time. Like you can say, all the preferred stockholders who are buying in this round get a director. Pretty common. Pretty common. So we're kind of approaching the end here. There's a lot more to cover, so we'll pick it up in the next episode.
Absolutely. Jeff, thank you so much.
Thank you.
All right. That wraps up today's episode of Partnered Up, Business Law, Deals, and Dynamics. To learn more about Jeff Fink and his work with business owners and partners at Coren Lichtenstein LLP, visit cl-lawgroup.com. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show for future episodes, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.